In Chapter 18, we look at employment law. Historically, employment law was governed by the common law doctrine of employment at will, which means that either the employer or employee could terminate the relationship at any time for any reason. Today, with all the federal and state law, it's a lot easier for a employee to quit than it is for an employer to fire them. Unless there's a contract, it's employment at will, and there are several exceptions to that employment at will doctrine. One is the contract theory. Is there some kind of implied agreement between the parties or an oral promise from the employer? An example would be an employment manual that sets out procedures that need to be followed maybe before firing an employee, and it's implied that all employees would be treated that way. A tort theory that it's more like how you fire somebody. It might be a wrongful discharge claim. Public policy that the courts would just say that it's against public policy to, or some statute to fire somebody for that reason. For example, whistleblowing statutes, statutes that encourage employees to blow the whistle on their employer would prohibit the employer from firing an employee who blows the whistle on them. And even if there's not an express employment contract, the employer's actions could result in a wrongful discharge action, potentially some kind of tort action or breach of an agency duty that's owed. One example would be, firing somebody in a way that is defamatory, saying something about them that's not true, like they stole something when they didn't, and that harming their good reputation. There's a variety of different laws in the area of employment under wage and hours. We've got the Davis-Bacon Act in terms of a prevailing wage, the Walsh-Healy Act in the beginning of a minimum wage, Fair Labor Standards Act is an extension of wage and hour regulations to workers who are engaged in interstate commerce. There are some overtime exemptions under the FLSA, and employees who work over 40 hours a week are entitled to 1.5 times their hourly wage for hours worked. So it's not a per day basis, it's over a total of 40 hours per week. This doesn't necessarily apply to executive employees whose primary duty is management. And it doesn't apply to salaried employees. Layoffs. The Worker Adjustment and Retraining Notification Act requires 60 days notice before a mass layoff, and that's defined in the law. And there's some additional to notification requirements, some remedies for violating the act, and there may also be some laws at a state level that require layoff notices. FMLA requires an employer with over 50 employees to provide up to 12 weeks or 26 weeks for serious injury or military duty of unpaid leave to employees who need to care for a spouse, child, or parent or themselves suffering from a serious medical condition. Employer needs to continue their health care and restore them to the position that they were in or a similar position. This is the case unless they're a key employee. Violations can result in damages, job reinstatement, or promotion if it was denied. OSHA, and there's also MIOSHA at the state level, is a federal law aiming towards safety in the workplace, and it's enforced by, the act is enforced by OSHA and other federal agencies. State workers' compensation law is a state statutes establishes administrative procedure for compensating workers injured on the job. Basically, instead of suing your employer directly, you recover under workers' comp, and there's requirements for receiving this compensation. And the two big things to look at are how the injury occurred and where it occurred. So it has to be on the job, and it has to be, and that could be even at some remote location, and it has to be, not the employee's intentional acts, but it could be a coworker, the employee's negligence, or even the employer's negligence. Other areas of worker health, safety, income, Social Security, Medicare, even private pension and unemployment insurance. COBRA is about continuing health care and insurance after employment, so whether it's voluntarily leaving or getting laid off. There's a procedure to follow, and you do have to pay for it, and that can be rather expensive if you don't have a job. There's employer-sponsored group health plans. HIPAA doesn't require health insurance, but does require establish requirements for health plans, and limits the employer's ability to exclude pre-existing conditions, and dissemination of patient information is tightly controlled. Some of the issues that come up in the employment setting are employee privacy rights. It's difficult to supervise all employees at the same time in multiple locations. One solution is electronic monitoring. More than 2/3 of employers use some sort of electronic monitoring on employees, but this could raise some privacy concerns. For the most part, they're not areas where there's an expectation of privacy, so you are able to monitor employees' phone conversations, video. There are prohibitions against intentional and unauthorized access to stored communications, so drug testing is another area where it could be a privacy implication. Another area in employment law is immigration. There's the Immigration Reform and Control Act, the Immigration Act, requirements for I-9 employment verification for new hires, paperwork that needs to be done for alien registration. A big area in employment law is employment discrimination. These are the common ones that the book talks about: Title VII, Age Discrimination Employment Act, Equal Pay Act, and the ADA. Title VII prohibits discrimination in employment on the basis of these categories: race, sex, color, religion, national origin, and that would include gender or sex discrimination would include pregnancy, because only one sex is getting pregnant. Implies that employers involved with interstate commerce with 15 or more employees. In addition to prohibiting religious discrimination, it requires employers to make reasonable accommodations on an employee's religious practices. The EEOC monitors compliance with Title VII. There's both intentional and unintentional discrimination. Another way of describing intentional discrimination is disparate treatment. If somebody establishes that they're a member of a protected class, they applied for employment, were qualified and rejected, and the employer went on to seek other applicants, they've established a prima facie or on its face case, and the burden shifts to the other party, to the employer, to show some other legal reason for not hiring that person. Unintentional discrimination is still discriminatory, violation of the law. It's called disparate impact. It occurs when a protected group of people is adversely affected by an employer's practices, procedures, or tests, even though they don't on their face appear to be discriminatory, tend to look at the pool of applicants. The plaintiff shows the percentage of the protected class in an employer's workforce is not reflective in the local labor market. As we said earlier, Title VII prohibits both intentional and unintentional or negligent discrimination, including employment policies on the basis of race, color, national origin. Policies that discriminate are illegal unless they have a substantial demonstrable relationship to a realistic qualification for the job. There's also claims of reverse discrimination, protecting majority groups from discrimination to undo past discrimination. Sometimes this is referred to as affirmative action. In discrimination based on religion, we were mentioning earlier that we need to make reasonable accommodations for sincerely held religious practices of an employee, unless to do so would cause an undue hardship to the employer's business. Discrimination based on gender. Employers are prohibited from classifying jobs based on gender unless the employer can prove gender is essential to the job. And there's some other laws that impact gender. Even though somebody's not actually discharged, they could be constructively discharged. This is where an employer causes the working conditions to be so intolerable that a reasonable person would feel compelled to quit. They could be constructively discharged even though they leave voluntarily. This applies to all Title VII discrimination. Plaintiff must present objective proof of an intolerable work condition, which the employer knew about and failed to correct, and the employee's resignation must be a foreseeable result of the working condition. Sexual harassment falls under Title VII. There's a couple kinds: quid pro quo and hostile work environment. Quid pro quo means this for that, involves demanding sexual favors in return for favorable treatment and job opportunity, promotion, salary, benefits. Hostile work environment means that the environment is permeated or is full of discriminatory conduct or intimidation, ridicule, insult. This would be an example would be putting inappropriate pictures on computers, email, posters on the wall, that type of thing. Remedies under Title VII could include reinstatement, back pay for the time the person was not employed, retroactive promotion, and even damages. Separate from Title VII is the ADEA, the Age Discrimination Employment Act, protects individuals over the age of 40 from workplace discrimination that favors younger workers. Basically, you need to show that you're part of that protected class, meaning that you're over the age of 40, and that the discrimination was based on age bias. The bigger that age gap, the more likely it is that it's a bias. State employees aren't covered by the ADA. The ADA, the Americans with Disability Act, requires employers to offer reasonable accommodations to employees or applicants with a disability who are otherwise qualified for the job they hold or seek. To prevail, a plaintiff needs to show they have a disability under the Act, they're otherwise qualified, and they were excluded solely because of the disability. So if they can establish those things, then the most difficult part is showing that that was the reason that they were excluded, not hired, fired, treated differently. Disabilities under the Act is a physical or mental impairment that substantially limits one or more major life function or activity, or a record of that impairment, or being regarded as having such an impairment. The 2008 amendments reverse the Supreme Court's narrow definition of disability, and now it's determined on a case-by-case basis. Reasonable accommodations might be a wheelchair ramp, flexible working hours, training materials. Um, Remember that while there's a requirement for reasonable accommodation, it has to be without undue hardship on the employer. This could include job applications, physical exams, substance abuse even. Um, Defenses. One defense is that it's a business necessity. It requires the employer to demonstrate that a job qualification is reasonably necessary to the legitimate conduct of the employer's business. And business necessity would be a defense to that disparate impact discrimination. A BFOQ, or bona fide occupational qualification, requires an employer to show that a particular skill is necessary for the performance of a particular job, and this could be used in cases of a disparate treatment discrimination. A valid seniority system may be a defense. That job benefits were distributed based on the length of time somebody worked for an employer. And it can only be a defense if it's a bona fide system, not designed to evade the effects of an anti-discrimination law. And then after acquired evidence refers to evidence of misconduct on behalf of the employee who is suing the employer for discrimination. If during this lawsuit evidence is uncovered, that's typically something that can be considered, but it's not an absolute defense to discrimination by the employer.